town boards, such as Historic District Commission, Conservation Commission, anybody like that. And I'm just giving you my experience on it. It's a very sound policy because you don't, these are your friends and neighbors. Everybody's volunteering to do this, and you don't want to be on opposite sides of the V sign. But in the event that that ever occurred, town versus Conservation Commission, yes, under that charter provision, you'd have the right to vote your own special counsel.
Thank you, George. Seth, do you have a follow-up to that?
Yeah, just quickly, so that perfectly clear about this. So I understand if the town is the named party plaintiff, First Conservation Commission, what if it's SPPF who brings a suit only, but would the town be considered a party given their status as the property owner or not?
Right, I don't know the answer to that. I'd have to look at it in the event that occurred. I'd rather not speculate on it hypothetically, because you'd have to look at the nature of the cause of action, whether the select board agreed with it or not, and a whole bunch of issues could come in. So I'd rather not answer that in the hypothetical.
That's fine, thank you.
Maureen, I saw your hand up.
George, this has been interesting to listen to. The issue I think a lot of us are struggling with is not, it's just, I believe, I certainly find it disappointing that the select board has had a course of conduct going back quite a ways, which has been doing their best to, what's the right word for this? That they have been providing guidance and actions, which to my mind have really not been helping our need to follow the law that we must and act as we have promised to act and sworn to act. Our job is to apply the law to the facts and evidence presented before us and to make determinations. And I would think the job of, say, the defendant, if you will, in this case, or the appellee or whatever, the Sconset Beach group, they had a lot of choices even before 2020 about filing amendments to the order of conditions, providing information about their difficulties with the sand earlier than they did, because this didn't all come out at once. Taking suggestions that Greg Berman had made in almost every annual report, and none of which they did. They didn't come to us for an amendment. They didn't take any other suggestions from our own independent expert. And then when we, after much agonizing, when we decided that, years of failure to act as if there was a regulatory standard for any of this, and not even bothering to come to us with an amendment proposal, that they decide somehow that if they can get the select board to hire a consultant to look at this one stretch of the coastline, that and the select board would appear to be in agreement that the Arcadis report is to be used like that, because they have not, the Sconset people have said that many times. They link the two together. And so we have this question of people who refuse to to go along with the law, to be honest and upfront about what was going on. And instead they waited till literally we had finally lowered the boom on them. And all of a sudden, this becomes an issue where we are actually asked to take back a decision we made. I think it's unprecedented myself. I think it is and as much as we keep hearing that no one's trying to undermine us or criticize us, I personally believe that when the select board comes to you, and after having a executive committee meeting to which you are not invited and cannot make your own case for why you think this should happen, other than a one-page form, which Jeff did file, they make their decision to ask us to undo something that is the product of months and months and months of deliberation, thousands of pages of record, that the SBPF has admitted clearly that not only have they been in violation for years, not just once, years, they don't plan to go into. They plan to continue to violate unless they can tie this dispute over an enforcement order under for the existing project. They want to tie that to the litigation for the proposed project. Now, all along, we have been told that these are two separate issues. We can't, whatever is happening on the enforcement side is not pertinent to what's happening on the litigation side, and I always thought that was the right thing. If they screw up on one thing, it doesn't necessarily mean they would screw up on the next one. But what we have now is an appellee who is joining the two together and a select board that is supporting them in their quest to have us change our minds to now, years after it would have been appropriate, we're now supposed to go through some kind of process to go on a process to then figure out how we can undo our order and somehow, I guess, ignore the facts and laws that we went on beforehand. I mean, I personally think I don't think that's available as a choice to us, George. We have an obligation. And if any other applicant came to us, frankly, after years of being in violation and saying, oh, well, this is really a problem and we can do it and own this other litigation we have to put them together and you have to back what you did. I mean, it's mind. I find that quite unbelievable. I find it really sad since the Wisconsin people had other choices, the select board had other choices. They're busy. Why not let us do our job? Why not appoint qualified people and have qualifications for the people who are going into any particular commission, and support the Concom in the actions that we have taken in good faith. I'm just really stunned. And I think it's very sad we did not need to be here today with us all worrying about whether you can represent us while still representing the SB, representing the select board. I don't know what you said to them. I don't know what opinions or counsel or advice you gave to them about taking these actions. I'm sorry. It is so beyond the pale. And I'm very, very sorry to hear what you have said. I disagree with your characterization of almost everything. And I am I'm just really sad that we are here. I thought we were all supposed to be working together, and we've got a bad actor who gets the support of the select board, and I don't think that makes sense. Thanks.
Mark, I saw your hand up.
Yes, thank you. George, I understand your preamble and your representation issues. I find it troubling. We know what the town wants us to do, and that's reverse what we have done with the order. It's the same things that the Sconset Beach people want us to do. So it's obvious where they're trying to lead us. And I just am very troubled by the fact that I don't think we're getting properly represented, because we know where your position is regarding the selectmen and the Sconset Beach Preservation Fund. And they're not where we are. And I would hope the town would help us in our deliberations on how to move forward with counsel for us. And I just find it troubling. I echo Maureen's comments about the length of the violations and the fact that I'm a relatively new member of the board, only a year plus, but I've been following the Sconset Beach issues for years, as most islanders have. And it's been a troubling series of violations there. And I just think that we need representation that's specific for the Conservation Commission and truly not for the Board of Selectmen, which is where you are. And I get it, but yet I don't like it. It frustrates me. Thank you.
Mark, any other comments or questions from commissioners at this point?
Ashley, I just want to note in response to that, first of all, to clear up something, the Arcadis process was a contract that the select board entered into with Arcadis. It was not generated by SPPF at all. And in fact, SPPF was unhappy with any types of delays on the select board's decision-making with respect to their issues and expansion of the structure or taking over the existing structure. And the select board entered into that contract in good faith to try to get an independent, respected firm to come in with relevant areas of expertise to give. And again, you can take it or leave it, what they recommend, but they were to look at it, interview stakeholders. They did not interview the commission, because I had advised very early on that if some type of new project application came as a result of that process, the commission would be the one to rule on that project within their jurisdiction, and that the commission shouldn't be part of that process. Arcadis was to come in, listen to all the experts, listen to the competing parties, anybody who wanted to give input, Coastal Conservancy, Nantucket Land Council, they're well-respected experts, the project proponent, SPPF, neighborhood owners, anybody else who wanted to comment in that process and give their good faith recommendations concerning short-term and long-term recommended measures for that area of the coastline. So any type of, I want to dispel right now that had anything to do with SPPF in terms of SPPF's involvement in that. SPPF had the right to comment on that process, just like anybody else had the right to comment to Arcadis and be interviewed and to give their positions. And Arcadis is to make recommendations to the town in their professional opinion, which again, reasonable minds may disagree with, but that's what that process is designed to do. And I'm very sorry and respectfully, but to suggest that reconsidering and trying to examine whether a proposed mitigation plan to resolve an enforcement issue is unprecedented, I don't know where the basis for that would be. Enforcement issues are attempted to be resolved all the time by conservation commissions, and it's in direct accordance with policies set forth by Mass DEP in an effort to resolve issues short of a court action. I've been 2 or 3 years into litigation in court actions, and it ends up getting a resolution which is ordered by the Conservation Commission in that process after years of litigation. So this is not something that's unprecedented for someone to try to work out enforcement issues with you. And the select board is not suggesting, nor am I, that you're to ignore your applicable performance standards or conditions of the permit. All they're asking you to do is to look at the plan which has been presented and see if that can bring this project into compliance on the issues that you've raised. That's all they're seeking from you. So I'm sorry if you're unhappy about the process or find it somehow nefarious, but it's perfectly above board, and it's not unprecedented at all for someone to seek to be on the same page within one municipality and to seek to resolve enforcement issues.
Thank you, George. So, I have to say, I appreciate that the town has contracted Arcadis, because the town of Nantucket themselves as an entity does need to do coastal planning, like 100%. But I do see it as a separate process from, the current permit in place. I can't see that Arcadis would say, yes, continue, working with a project that is consistently out of compliance. I don't see that happening. I also, just want to state that the commission has worked to resolve enforcement issues on this project, and enforcement issues on failure criteria. So at what point does a failure criteria actually signify failure, in your opinion? Because the last enforcement with the construction debris contaminated fill, we were pretty close, I think, to asking for removal, and then there are still failure criteria being triggered. So for me, that actually now signifies a project failure. It's gotten to that level, and I don't know that it's fair to kind of have the commission seem like we don't want to work with an applicant, because we have, and it's seemingly gotten to the point where they're not working with us. My other kind of question, because, I realize SBPF presented a proposal to catch up in 4 years, but that proposal is contingent upon an expansion. So if we were to say, okay, we'll accept this proposal, who's on the hook if they don't get their expansion and then still have not made up for the deficit? It'll be back on the Conservation Commission to deal with the issue. And I just don't see that as being good process, because they need to say, we're going to do this for the 4 years regardless. And I don't know if that's a separate permit with the select board, where it's, a true legal document separate from us. I just don't know how that goes, but
well, you would have to do it in accordance with your procedure. So if you were to, there are various ways of doing it. You've done it before. You could do it by way of going ahead with an enforcement order. If you have some plan, you issue the enforcement order. Here's the conditions of the enforcement order, and then that party subject to the enforcement order has conditions spelled out, and that then bring it back into non-compliance again. I mean, there are, this is done. It's not something that is infrequent, and and I'm not criticizing the Conservation Commission in any way. I'm just trying to articulate what the board's position is to the commission. They're trying, and again, they have a lot of competing interests and concerns, and they have policy issues that are not within your jurisdiction, and that are irrelevant to you, but that are relevant to the select board. And the select board is just trying to seek a solution one step at a time. Okay, here's a articulated enforcement issue that you've ordered. Sorry that it came to the point where you actually had to enter an order, vote an order on it, but we're requesting you to consider this mitigation proposal. But you could definitely, if you found it satisfied the enforcement issues, you could craft that, in the form of an enforcement order that, then has conditions of compliance. And then what happens in the future happens in the future. You'll have to deal with that issue then, but you would have an enforceable order if you wanted to resolve it that way.
Okay. Thank you. And George, I definitely recognize the difficult, position you are as well in this situation. Ian, I saw your hand up.
Well, you did, Madam Chair, and you know what? You pretty much, everybody else has covered it. But George, would you like to retract your nefarious comment? That means wicked or evil. I can read you the OED definition. Nobody has mentioned anything at that level that I'm aware of. And I think that's a really unfortunate choice of word, especially since we've worked with you for years.
Well, I took from the two speeches that were made that there was something improper that I was doing, that it was unprecedented.
No, I believe they said
shocks
one
the
said
conscience or
one
whatever the
said that
words
they
were.
were sad, and the other one said that it was an awkward position.
Okay.
I'll retract the word nefarious, but what I was trying to articulate to you is that there's nothing in bad faith being presented to you. And quite frankly, if you want to get angry on it, I'm an attorney. There are policies and charter provisions in place, and I'm articulating to you what role I'm here today in. So if somebody tells me that my presentation is sad, I'm going to respond to it.
No, they said that they felt that the position that we are in is sad.
I think that we can all agree that this is a difficult position for everybody involved here. Everybody involved. George, the select board, and we as the Concom. I think what we need to remember as conservation commissioners is we, again, like George said, can take or leave what he's saying. He's here because the select board has allowed him to be here. We can listen to what he has to say and we can make our decision. But I think it is important to, remember that we are in the same community. And again, we're all in difficult spots here. This is not easy.
I have my hand up when you get to me.
Okay, Linda?
Having sat for years on the ZBA, large percentage of it with Mark Beale, back in the day, there was an issue between the planning board, I believe the ZBA, that the select board, selectmen at the time had to mediate because we didn't want to go around suing each other. I believe the planning board was up against the ZBA and it was headed towards litigation. It was mediated by the selectmen with a joint meeting in the old courtroom. And it was worked out because we were all ultimately on the same side. We had to come to some sort of a stipulated agreement. And I think we are all on the same side now. I understand there's quite a history of violations, alleged or otherwise. But I think the town has finally stepped up to ownership. George listed a lot of the stuff I was aware of on the planning board that they were doing about getting an easement for access, et cetera, and some other things in place. I think the town has finally stepped up with hiring Arcadis, and it's not a cheap hire. And I think I respect the commission's history with this, but I think that jumping to an enforcement order for removal might have come at the wrong time vis-a-vis hiring of Arcadis at that time. I think it just converged, unfortunately, at the same time. So I don't want to get into an adversarial position where the town sues us or becomes a party to the opposition. And I think we need to step back. They're not telling us what to do, because I've been over this with the ZBA and the planning board with the adversarial position with the select board at one point. They're not telling us what to do. They don't have any legal right under state statute to tell us how to rule or what to do. What they're asking us to do, and I don't get lost in the weeds here, they're just simply asking us not to go forward with the enforcement order at this time and come up to some sort of a mediated agreement while Arcadis does its thing. And so that's my position at the moment. Thanks.
Thank you, Linda. Seth?
Thank you, Madam Chair, and thank you for keeping it civil. I think that an enforcement order is going to be required in either case, whether it's a removal order or whether it's a order to accept the sand mitigation project to bring this back into compliance. There's no way we could do that without filing an order to compel those conditions. But I think, you know, there's going to be some enforcement issue here either way. But I do think that if you look at the history of this project, there's been 3 recorded enforcements prior to this. And this is the 4th enforcement. And I think that what you say as the chair is correct, is that you need to consider not only the issue at hand, the sand mitigation, but you have to consider how the permit holder is going to hold their good faith deal in an enforcement situation. It's pretty clear and evident that the permit holder is only interested in bringing this project into compliance if a expansion order is authorized, and with no known insight into whether that will happen in the future or not. It may not. It may get stalled for so long that something else is proposed. I think we need to stay our course here and let the permit holder, you know, think creatively about how to handle this situation in Baxter Road generally. Let them listen to the results of what Arcadis come up with, and let them come back to the table later in the fall with a different solution. But I think the current project as existing is not meeting the performance standards and has a history of non-compliance that even if we temporarily could bring it back into compliance, will likely go out of compliance again in the future. So I don't think that my position here is that what we're doing isn't an end to, you know, coastal management projects in that area. It's a temporary stop to a non-compliant permit holder and a non-compliant project that gives us the opportunity to look at the results from Arcadis and for the town and the SVPF to think creatively about how to better manage this whole area in the future. That's how I see it.
Thank you, Seth. Any other comments or questions from commissioners? Okay, so I will open this up to public comment. Please do not repeat comments that have already been said or anything else that's, you know, previously in the record is already part of the record. So comments or questions should pertain to tonight's discussion, our denial of counsel and the enforcement issue. So at this time, if there's any public comment, please raise your hand. Jeff?
Real quickly, I was just going to say to folks, if they look at the bottom of their screen, there is a reactions button that's there, and the raise hand feature is within that. So if people want to use that are not on camera, that would be an easy way. I know Mary and Dennis both look like they've successfully done that. So it's under that reactions tab. There's a raise hand. If you use that, it would probably be much easier for you.
Yes. I don't know. Jeff, I might not be able to see the raised hands because I'm not a host, so you might have to tell me.
Okay, well, the first one that I saw was Barry Warrow, and I'll try to change that so you can see those, Madam Chair.
Okay, perfect. So Mary, I'll recognize you.
Am I on? Can you hear me?
Yes, we can hear you.
Okay, thank you. Members of the commission and Mr. Pucci, I want to say I'm happy to see George again. Haven't seen him for a long time. And I also want to say that George Pucci has represented, in my mind, has represented the Conservation Commission for many years. I think possibly even back to the time when I was on the commission, which was, I think, possibly in a, well, was it in a different century? May have been. Anyway, I have a couple of questions, George, and a comment. I know that KP Law is one of the premier municipal law firms in the state of Massachusetts, and that it has represented the town for many years. My question to you is, does KP Law and has KP Law considered itself the attorney for the town, meaning the select board and the Conservation Commission? My understanding is that you, George, have been representing as an attorney the Conservation Commission, and you have been representing the select board. Am I laboring under a misapprehension there?
George, you can answer that.
Yes, I always answer questions through you, Madam Chair. Nice to see you or hear you, Mary. No, we're town council in accordance with the select board's selection. I've represented the commission as the named party to litigation for many years, but that's as authorized by the town manager, subject to select board approval under that charter provision that I had talked about, that approval or disapproval to prosecute, defend, or compromise all litigation to which the town is a party. So we've represented named parties such as the Conservation Commission or the Historic District Commission, Planning Board, wherever you can think of, but only as authorized by the select board. So that, and what I tried to explain at the beginning of this meeting is the select board's vote was very clear that they're not going to authorize, at least at this time, regarding enforcement issues, they're not going to authorize the commission to hire its own special counsel, but they are authorizing town council to confer with the commission, and the commission can take or leave it, what our opinion is. But I'm here as town council, as requested and authorized by the select board. So I, represent the town in accordance with that policy that I cited, to provide impartial and unbiased legal advice clearly, efficiently, and cost effectively, and to articulate the select board's policy decisions in this. But it goes no further than that. The vote is clear that the select board is not authorizing special counsel. So I'm here as town council.
Yes, Mary, do you have a follow-up?
Yes, I do. In fact, I have a couple of other questions that I wanted to pose, if I may do that through you.
Yeah.
I've looked over the rules of professional conduct for Massachusetts attorneys, and section 1.7 says a lawyer shall not represent a client if there is a concurrent conflict of interest. Such a conflict of interest results if representation of one client is directly adverse to another client, and or there is significant risk that representation of one client materially limits the lawyer's responsibility to another. Now, I understand, and correct me if I'm wrong, that what you are saying is that you and KP Law have never been lawyers for the Conservation Commission. Do I understand that correctly?
No, you don't. You don't understand that correctly. It's exactly the opposite of what I said. We've represented many times named commissions or boards, depending on the party named in the litigation. So, I'm going to answer respectfully, Madam Chair, a certain amount of these questions as they're relevant. But the issues before you, I'm here for a very clear reason: to follow up on the select board's vote, to articulate it to you, to give you the courtesy of offering town council advice. I'm not going to get into the ethics of KP law or me as an attorney or anything like that. It has absolutely nothing to do with the issues before you. As I said at the beginning of this meeting, the select board's request is very clear to you. They're requesting reconsideration. You don't have to hear from me at all. I was invited to be at this meeting, and anything I say to you today can be completely disregarded to you as biased, incorrect, stupid, or whatever else you want to think or judge it to be. But I've been very clear about my role here today, and that's how far I'm going to get into it.
Right, well, I do have one comment, and that is, it is my belief that every member of the Conservation Commission that currently is sitting and that has sat, since KP Law became town council, has believed that KP Law and George Pucci that the Conservation Commission was in an attorney-client relationship with that firm. And if that was not the case, that should have been made very clear at the very beginning. And I also want to point out that if an attorney has two clients and those clients are in adverse positions, the attorney can no longer represent either client without the informed written consent of the other client to continue to represent the other client. So I'm curious as to what KP Law's position is with respect to that. I find it as other members of the commission have said, that an attorney and a firm that has been relied upon by the commission for many, many years is currently in this position, and that the commission is getting this news. So that's my comment. I have one final question, and that is, well, two points. One, I take it then that it is not your view that the select board needs to waive a conflict for you to be continuing to advise the Conservation Commission, because you are not advising the Conservation Commission. You are not the attorney for the Conservation Commission. The Conservation Commission now is without legal counsel. My last comment is, I was struck by your description that the touchstone of when there is an issue that would require separate representation is when the parties to a litigation are in question. And your point, as I took it, was that if the select board if there were plaintiffs and defendants, and the select board was on one side or the other, and the conservation was on the other side, that would require appointment of a separate counsel. In this situation, there is existing litigation. There's existing litigation regarding the denial of the permit for the expansion. And in that case, the plaintiff is SBPF and the defendants are, as far as I'm aware, the Conservation Commission and the town. By requesting—
No, they're not. I'm going to have to interrupt you, because I apologize for interrupting you. I would never do that, and I respect you a lot, and I don't interrupt people when not asked to do so by the chair. But you need to stop having misrepresentations in what you're saying and leaving them out there. I don't believe that the town is a party to the SBPF versus Conservation Commission case. And I've also made it very clear that I'm here as town council. There is no disclosure needed from the Conservation Commission tonight for this meeting. I'm here as town council.
I have the caption to the case, and the town is a defendant. So apart from that, these matters are related. The matter of the enforcement order and the matter of the denial are related, because SBPF has related them. SBPF's position is, if we can't do the expansion, we will, and we don't get our way with respect to the existing project, we're going to turn this over to the town. So the town, by joining with SBPF, is in effect taking an adverse position to the Conservation Commission. And it may not be in litigation now, but there's going to be litigation. So that's my comment. And if we have differing views, we can discuss that at another time. But my final question is this: is it your view as the attorney for the Select Board that the Conservation Commission's enforcement order enacted on June 30th is in any way, shape, or form an order that abuses its discretion, that is arbitrary and capricious, or is in any way improper, so that a lawsuit filed against the Conservation Commission in the Superior Court could move forward?
Thank you for your comments, Mary. I know there's a lot of confusion about this. George?
Actually, there's no reason for there to be confusion. I was very clear. I'm here as town council. The Select Board denied the request for special counsel on the enforcement issue, and the Select Board is asking reconsideration of your order. That's all that is before you. You're free to act on that however you want to act on it. There is no pending lawsuit that the town is suing the Conservation Commission.
Okay.
So, and that the charter provision in question that was just quoted or paraphrased, I quoted in specific answer to your members, Seth's question specific to that issue. And that's when that comes up. It doesn't require it. It gives a board on the defendant side of a case in which the town is a party plaintiff. It gives them the right to make that determination. Doesn't require it. And there's no disclosure here involved at all. I'm here as town council, very clearly articulated to you. And town council gives opinions on issues all the time, as authorized by the town manager and Select Board with regard to a myriad of issues involving the town. And that's in our role as town council.
Thank you, George. I know since we made our decision, there have been a lot of very new situations I've had to deal with, and some of them have been, in my perspective, confusing, but I do understand the role that you are in this evening.
And the long and the short of it is, again, the Select Board is seeking to bring this into compliance. And as your member, Seth, earlier pointed out, and I agree with, they tend to be the best way of resolving enforcement issues where a commission is satisfied with a proposal to bring something into compliance, to do it through the issuance of an enforcement order with conditions, because then it's very clear what you're ordering. And it's very clear in a month or two whether it's in a violation or not, and where you go from there. So you would deal with that then, but it is a very clean way in the event that you were satisfied with the mitigation proposal or wanted to condition it further, you could do that through the means of an enforcement order.
Thank you, George. So Stephen Cohen, I see your hand up, and then Dennis Murphy will go to you.
Sure, Madam Chair, I'm willing to let Mr. Murphy go first. I'm fine with that if the other members of the public want to speak first.
You can go ahead, Steve, and then I'll give it to Dennis.
Okay, so a lot has been said, and I think it's slightly unfortunate that some people have suggested that they think that they know what other people's intentions are or what other people's future actions are. So on behalf of SBPF, I just want to be very, very clear that obviously, first of all, that nothing really happening today is between SBPF, this is a Concom and Select Board conversation. But I do want to be very clear on the facts that there is the commission is considering an enforcement action, and we heard the word unprecedented before, and I think what's unprecedented would be for the commission to order a removal action without consideration of a remediation action that is being proposed by the applicant, and that would be unprecedented, and I think no one would ever consider Ernie Steinhauer to be other than the highest level of example of one of the best commissioners we've had, and Ernie was very fond of saying at these enforcement hearings, or that it's not the commission's job to punish people, it's or to enact draconian measures. It's the commission's job to bring things into compliance with either what was approved or what would have been approved, and he would say that at every enforcement hearing. And I think if we want to talk about what's unprecedented, frankly, I think it's the commission's vote to request a enforcement when there are remediation options available. And so I hope that the commission will take the select board's request to consider the remediation option that is being proposed, and I'll leave it at that. Thank you.
Thank you, Steve. I think in the same way, we shouldn't kind of assume what people might do in the future. We probably shouldn't assume Ernie would go one way or the other on this. I don't know that he would kind of appreciate being put in a camp without.
Yeah, I was just saying something that he consistently said in the past, not what he would say here.
Yeah, thank you, Steve. Dennis?
Thank you, Madam Chair, members of the commission. I have just 5 quick points. First, there have actually been half a dozen enforcement issues with this project, dating back to Carlson's letter from February 5th, 2014. There was another letter, October 23rd, 2019. The chair's letter to the select board in April of 2020 mentioned 3 violations. There was a monitoring failure, a cease and desist for the construction debris, and then a further violation of the cease and desist, and then this proceeding, which started several months ago with the review from the annual reports. My second point is that the commission has, I think, a regulatory role, and to date, you've followed the data and followed the science, and I would encourage you not to be dissuaded by what seems to be more politics. And that kind of brings me to the third point, which is because of what's happening with this disagreement over compliance, my understanding is that we're almost 8.5 months into the year with no sand mitigation going onto the project, and the deficiency growing. Today, we brought Dr. Kriebel because, and this goes to my fourth point, if the commission does choose to reconsider the votes it has taken in May and June, I think that certainly those of you who were present and read that record probably don't need the tutorial, but if new commissioners are going to participate, then Kriebel is available, whether it's tonight or at another time, to talk about the effect of the continuing non-compliance. Because remember, this started out with the 2020 review, and here we are now more than 8 months where there's been further deficit. 2 other quick points that go to the situation the commission finds itself in. There's legal support for issuing an enforcement order. 310 CMR 10.08. Carlson's well aware of this. You commissioners who've been involved in enforcement actions are well aware. You absolutely have the authority. In fact, there's a form and WPA 9 where you can issue, and you have issued enforcement orders on that form. The one thing that I would suggest that you bear in mind is under the regulation, you need a majority vote. I think you've already had that vote. You have authority to issue enforcement for a violation of an order of conditions. You also, the one thing that hasn't been discussed so far is that there's also a 2-year statute of limitations. And generally, if it's a continuing violation, you don't get tripped up by the 2 years. But one word of caution I would suggest is that if you don't take action now, one could argue in the future that if the violation is more than 2 years old, you're time barred from taking an enforcement action on that. The last point I'll make is about the effect of an enforcement order. I think town council was very clear in his articulation of the current procedure, but my takeaway from his guidance was that any enforcement order is appealable only to court. And if and when that were to happen and the commission finds itself as a defendant in such a proceeding, you will be provided counsel. That much was clear. I think that is the exception under the town charter that town council cited. And basically that's all I had. And if there is going to be reconsideration, I would just ask that it be done in public. And that if the commission is so inclined, we'd be happy to have the experts back to inform the commission's decision making. Thank you.
Thank you.
Ashley, can I just add and follow up to Attorney Murphy's comment? Just in case I was unclear, I don't think I was, but it could happen. I just wanted to be clear that the select board was requesting reconsideration of the vote to remove the structure, which would be different than asking you to reconsider any type of enforcement. As I said, in the event that you were to reconsider the order of removal that you voted, I definitely agree that it's, the preferred practice to go ahead through an enforcement order. If you're satisfied with that, or you think it can be conditioned appropriately, the proposed solution to bring it into compliance, that you go ahead and do that by way of an enforcement order. And as I said, then you have clear conditions that either are complied with or they're not. So that would be something to be determined in the future. So I just wanted to be clear, they're not seeking reconsideration of the enforcement issue or order per se. They're just seeking reconsideration of the solution being the removal order. But I definitely agree that an enforcement order would be the appropriate mechanism in the event that you think you can work with SBPF's plan to condition that accordingly through an enforcement order. Go ahead and issue that. And I would definitely also agree that you're free to take in further information, expert advice from other parties, such as cited by Attorney Murphy, or however you want to deal with that. You could take further input in conditioning that enforcement order. So I just wanted to be clear on that.
Thank you, George. So at this point, I don't see any other hands up, and I don't want to miss anybody on here who wants to comment. Stephen, do you have another comment?
No.
Okay. So at this point, commissioners, do you have any other comments or questions? No. So I guess we're at the point in this meeting. I mean, Jeff, would you recommend us or someone, if they so desired, to make a motion to reconsider? Is that where you think we would be before the end of this meeting?
I mean, I think that's certainly one outcome for you, Madam Chair, to make a motion to reconsider. I would also say too, if you're going to go through that and reconsider and take that as a step, is there could also be, conditionings to that reconsideration. I mean, obviously, you could certainly ask to involve a member of the select board. You could ask them to provide, a review of their existing license. the conditions of that and compliance with that as part of that reconsideration. I mean, I think you guys have a lot of options when you look at that reconsideration to make sure that, you know, you're involving the proper parties and you're making sure that the interests that overlap are being sufficiently covered in both directions. And I think that I think there's the ability to set up a creative discussion to hear that out and still have the enforcement that's either pending or underway. But I do agree with all of the attorneys that have spoken that I think the end result of this, regardless of whether it's reconsidering and doing it that way or issuing the final removal order, I do think that the mechanism to advance will ultimately be issuing out an enforcement of some kind. And I really don't see any other way to kind of proceed without that being the end at some point for the structure that I don't think anyone was argue is not in compliance. So I think those are the steps that are there. But I think it's a decision that you guys are gonna have to make a bit. And obviously, if people want some time to think about it too, given the information tonight, we can obviously schedule for another time as well.
Okay, thank you, Jeff. So yeah, I think our options, and then Maureen, I'll go to you, would be either a motion to reconsider or a motion to, you know, continue along and, you know, ask Jeff to make sure an order of removal is drafted. So we kind of have those two options. And then Maureen, I saw your hand up.
Yeah, I just wanted to, I just wanted to, I with some hesitation, I return to my word unprecedented, which I guess has caused some amount of controversy. But I guess what I really felt was unprecedented is that we would be reconsidering because, and one of the reasons Mr. Cohen said was that remediation options are available. And I'm having trouble with that because the remediation options have been available since the first report of any kind of problem. So it's that I think is what is unprecedented. We're asked to ignore a course of conduct and go forward with accepting a potential, and go forward with going back on what we decided because of something that had been actually available all the time, and this is nothing new. So just wanted to make that clarification. Thanks.
Madam Chairman, I have one more comment.
Yep.
I believe George, having worked with George for a long time, I believe George said the board shouldn't be punitive. Is that correct, George, through the chair?
I didn't say that.
Somebody was
Steve,
saying it shouldn't be punishment, I believe.
I didn't comment on any type of policy perspective from the commission.
Ernie Steinar, Linda.
Oh, that's right. And I agree with that sentiment. So I just knew I'd heard it and it was sort of stuck in my head. So I would make the motion to reconsider if you're at that point.
Is there a second to Linda's motion? Looks like that motion is not carried. Is there another motion to be made? Seth?
No, but I think further discussion is warranted. I think yes, there needed to be a motion to reconsider. I don't necessarily think a motion needs, respectfully to you as a chair and to Jeff, I don't think a motion needs to be made to not reconsider. The board has already stated their position, so I don't think we would need another motion on that. I do take Jeff's point and would possibly like some more time to think about these things after all that's been said today. So I would entertain the potential of letting this sit and having another meeting, but I know there's only so many meetings we can do before we get to the resolution that is needed. but I don't think a motion is needed to not reconsider.
Okay, thank you, Seth. Mark?
Yeah, thank you. Question for Jeff and maybe for Ashley. Is there a time consideration we're worried about with having voted to order removal? Is there any time frame we're worried about here? Thank you.
Jeff, it looked like you had your hand up.
In this case, no, there is not. So we kind of have time. It's not a situation where we've closed a public hearing or there's a public hearing involved to invoke time deadline. So we do have time to craft it together. I think, you know, from an administrative standpoint, I think we need to take the time necessary to issue out whatever decision is made correctly and properly and make sure that there's not obviously an administrative hiccup or a paperwork hiccup to cause a problem. So I don't think we're bound by that directly.
Thank you, Jeff. Mark, do you have a follow-up?
I do. I just was asking Jeff if he's had a first draft proposal for the order of removal.
I have drafted one from the 30th. If you guys would like, I'm happy. I mean, if the commission wants to see that, we can send it around. I know we've sent it out to a few of our reviewers to take a look at as well and gotten comments back. But if you would like that distributed for further discussion, we certainly can. I would also add to that really quickly, if there's other information that you guys are looking for as part of issuing that decision, this may be a good forum to get those questions out if you're looking for something specific to try to get so the public knows, and then we can have that information to fuel whatever the next or final discussion is.
Thank you, Jeff. I think it would be good to get that circulated to the commission at this point. Ian?
Ashley, can I ask too, have you made the mitigation proposal? Is that before the commission? I mean, I don't think you'd be able to decide it either way without seeing that and thinking about it. And as Dennis had suggested, getting input from other experts or whatever. You know,
Yeah.
SPPF, it was my understanding, did submit a proposal.
They submitted kind of a short proposal with essentially the amount of extra cubic yards they deliver per year. That does contradict other mitigation proposals we've received from the Land Council and I believe maybe Mr. Murphy's client. So there are very differing sand values there that I think are quite concerning. But yes, we've seen a short draft, I guess, of what SBPF is proposing.
Okay. I just wanted to clarify because that was part of the select board's request, is that you reconsider removal, you know, to give a chance both to look at the proposal from SBPF, craft it accordingly, approve or not approve it, and also possibly if you were inclined to, we're getting close to the point where Arcadis is going to give their recommendations. So I just wanted to be clear just for one last time what the select board's request actually was to you.
Thank you, George, for clarifying that. I know when I look at the sand proposals, we have two entities saying, I believe it's like 47,000 cubic yards that need to be delivered. And then SBPF is about half of that. So that discrepancy is a little bit concerning there for sure, from my perspective. So, you know, that is what it is. But yes, we have that information. Mary, I see your hand back up. Do you have a quick comment? And then Ian, I'll go to you.
I do have a question, and that is Jeff's statement that his proposed draft has been circulated to various people. And I would say, I would question the sending drafts for comment to council for the select board.
It was not sent to council for the select board.
Okay,
So let's stop right there.
that's fine. Thank you.
Jeff, and then I'll go to
And I'm not counsel to the select board. Right? We are town council. And the select board has certain rights and obligations with respect to town council. So again, please, let's be clear. I thought we were now focused on the actual substantive issues rather than the esoterica about, ethical obligations and charter provisions and all of that. But let's be clear about, please don't characterize who I am and then leave that on the record to be left as something that is not correct.
All right, Jeff.
So I just wanted to clarify that the only other person other than myself that has seen any kind of draft is our third-party reviewer, who we were discussing what removal would look like in conditioning, as we had discussed on the meeting on the 30th. And that is it. It hasn't gone out to any attorneys, anyone else. It was just kind of elaborating on the points that had been discussed on the 30th with that party and kind of conceptual. So it's not like it's a heavy review by multiple parties. So I don't want that to be misconstrued either.
Thank you, Jeff. Ian, and then Maureen, I'll go to you.
Thank you, Madam Chair. Through you to George, I hope you won't take this as a red flag to a bull, George. I was actually going to ask, as your role as town council, whether you were going to review it or not. Thank you.
Yes, and again, Ian, I apologize for the nefarious comment. I promise I'll get a thesaurus and use better words. I try my best as an English major, but
I owe you an apology, George, for raising my voice. I'm really embarrassed. I apologize.
Well, we're a mutual fan society. You know the respect I have for you, so I apologize for that comment. But to answer your question, actually, that's another clarification in the event that the commission wants it. The town manager in her email about the select board's vote specifically said that the commission can consult with town council regarding the vote to order removal and crafting any related enforcement order. So, in the event, I think it's obviously clear it would be difficult for me to help Jeff craft an enforcement order if you go ahead with removal as your remedy. I am certainly available. But if you want that advice, I've been authorized to provide it. I would think where my advice might come in more helpfully in terms of my role as town council in this is in the event that you're looking at the proposal to bring this into compliance and you're thinking of crafting an enforcement order that would have conditions to bring this into compliance versus removal. The town manager has authorized town council to confer with the commission and with Jeff on that issue. And that's totally up to you if you want to accept that or not.
Thank you.
Thank you, George. Maureen?
Yeah, I had one thing, that piece of information that I've asked for several times during meetings is to find out where the escrow account that was created at the time the original order of conditions was issued, which was intended to pay for the removal should that ever be ordered. I have never seen any information on that. I don't know where it is. I don't know how much money is in it. And I think that is a relevant piece of information for us to have. Yeah, so I think we need to have that piece of info. And I don't know if we get the town finance department, Jeff, I don't know who you have to talk to, but this seems, I want to make sure this isn't ephemeral. I'd like to know that we have some money and how much is in it.
Yeah, I apologize for that, Maureen, but I will definitely have that prior to our next discussion.
Okay, thank you.
I can actually answer that question. It's Stephen. I believe the number was either $100,000 or slightly higher. It might have been 125 or 150, but I'm pretty sure it was 100. And I know that the money was put into an account with Elizabeth Brown, who at the time would have been the town treasurer. So that should be in a town account. Thanks.
Thank you, Stephen. So Jeff, it sounds like we are to the point where we would continue this discussion. I don't know what dates we have available out there to us.
That's, if you're through you, Madam Chair, that's an excellent question. If you'd like, I know we have our regular meeting tomorrow. I'm not saying that to continue the discussion to tomorrow, because I'm sure people want a little bit of time, but I think we can pull together a number of options date-wise in between tomorrow's hearing and the next regular hearing, with that regular hearing as backup as well, to give everyone some choices and kind of have that discussion in public for the next date.
Okay, and that'll allow us time to hopefully look at a draft order of removal and think about anything else.
Sure, I think we can pull all of those things together. And then Maureen had that question. Is there anything else that people are looking for to help with the discussion?
Commissioners, anything else you need?
Or if they do think of something, sorry again, Madam Chair, if you guys do think of something, please, if you could just email it to me and let me know as soon as possible. I'll try to get it together and get it distributed enough for the public to see.
Thank you, Jeff. So before we have a motion to adjourn, I do just want to thank everybody for their participation. I realize that, again, there are a lot of different kind of perspectives on this issue, and we're all kind of navigating through our own perspectives. So, you know, hopefully we can all see each other in the grocery store and still be able to smile at each other in the future. But at this point, I think we are ready for a motion to adjourn.
Also move.
All right.
Second.
Okay, so by roll vote, Beale,
Aye.
Engelbours,
Aye.
Harrisman, I, Golding,
Aye.
Phillips,
Aye.
Williams.
Aye.
All right, this meeting is adjourned. Thank you, everybody.
Thank you. Good night.